Welcome back. I'm Dennis Kennelly, host of On the Legal Line, and talking with me at present is Miles McNamara, who is the president and CEO of Comfort Keepers, which provides individuals that provide home care, which is, and increasing as our population ages and tries to avoid going to a nursing home. The best way to deal with that is to get some private in-home care, but there are costs and there are legal issues involved in it, and that's what we're discussing. Technically, if you've got, for example, a nanny, somebody that's watching your young children or even your not so young children, they are employees, so they are covered by the same wage orders that everybody else is. But you've got, and a wage order for example, a lunch period says that an employee should be permitted to leave the premises on their lunch break and to have no job-related responsibilities. Well, if they're a nanny, what do they do with the child? Because if they have to take the child with them, that doesn't work, especially if it's a break situation where you have to have 10 to 15 minutes of unfettered time where you're free to do what you want and you can't take the child with you. So what do you do? Miles, there is an out, isn't there?
Well, and I'm not too, I don't do children, Dennis, but I'm pretty confident that the same rules would apply in home care because of our seniors who can't be left alone, and the term is a duty-free lunch period, completely duty-free of any responsibilities or control. In the home care industry, we have what we call a working lunch and break waiver, where our employees know that they can't leave our clients unattended, so it won't be strictly duty-free. However, they do know that they will be paid for those breaks and lunch times, which is different than when someone does take a lunch hour or a break at a regular business. They're not paid for that time. So we have a waiver that our caregivers sign that can be revoked at any time, but again, it's that agreement between employer and employee that they understand that a duty-free lunch period or break is not possible when you're dealing with someone who needs your 100% attention 100% of the time. So I'm assuming that would apply with folks hiring for babysitters and nannies, where you really are not supposed to pay under the table. I mean, everybody needs, a 1099 doesn't work because they don't meet the criteria of a 1099 employee. So you basically have to W-2, and what I tell folks when they call into us is, if you're going to do that, you basically are becoming, in the eyes of California, a small business. And you have to follow all the rules and wage and hour laws of a small business. That goes to wage an hour, that goes to record keeping, that goes to properly signed documents and waivers, workers' compensation insurance, liability insurance, payroll taxes. You become a small business.
Yes, once again, the doctrine of unintended consequences.
Right.
All you're trying to do is get somebody to watch your kids, and 40 years ago that wasn't a problem. The only problem is now, what happens if grandma comes in and says, I get paid too?
Well, and we're such a litigious society, and it's gotten to be now where, you have, nannies or caregivers who are working privately, and that client passes on, or the job comes to an end, and they go to try to apply for unemployment. Well, there's no record because it's been cash under the table, so to speak. Now all of a sudden the IRS goes, hello, wait, what's going on here? And so there's back payroll taxes, which there's no statute of limitations on any of this. And then you also have the more savvy employee who are actually filing lawsuits against private families for wage and hour violations. A high-profile case not too long ago was our loving Betty White was sued by a domestic worker that she had on her payroll for years and years and years privately. Don't know how that was settled. It was, but bottom line, she was sued by this private domestic worker for wage and hour violations. Yes. Overtime, breaks, the whole 9 yards.
And they are not fun. And if the employer doesn't have the records, and mostly, largely, almost exclusively, people don't, meaning the people employing you.
Well, they don't know what they don't know.
Exactly. Exactly. I mean, they're not sitting down writing, that Joe or Jane stayed an extra hour or 2 hours on odd number Tuesdays, and the nightmare for the lawyer representing the homeowner, the people paying the caregiver, is you don't have records, but they've got a log.
Right.
And
I think the biggest scary issue, Dennis, is not only the wage and hour, which is a humongous scary issue, is the issue of workers' compensation insurance, because they think there's some money. And first of all, backing up a bit, they're not aware of the whole criteria of a 1099 employee. They think, oh, well, I'll just 1099 them. They don't meet that criteria, so that's going to get them in hot water. But if a caregiver injures themselves while they're on the premise caring for the child, the senior, whoever, I mean, workers' compensation cases can go well into the six figures depending on the injury. And again, the savviness of the employees and the workers' compensation plaintiff attorneys out there, it's such a risk of an injury happening in the home, and now that homeowner, that client, that employer, if you will be on the hook, not only for all the fees and penalties and violations of not doing it properly, but all the expenses of that caregiver when it comes to their medical treatment.
Exactly. And one of the things I tell all of my clients, or anybody that asks, is the first place you should look in answering that question, check with your homeowner's insurance carrier to find out if they have a workers' comp rider that covers this.
And more often than not, there will be a limit of liability. That's why I always advise people as well. Yeah, you have a rider, but now look at your limits of liability, because if you have a $10,000 limit, that's going to get blown through in the first couple of weeks of treatment.
Somebody falls and breaks their back, you're dead.
Yeah. So always, I know there are some homeowners policies that will put in that domestic worker rider for workers' compensation, but there will be a limit to that liability coverage.
Which means, and this is a little beyond my purview, but which means you have to look into an umbrella policy.
Absolutely.
Sitting on top of that with a higher limit of liability, because as Miles said, if somebody falls and breaks their back, dollar for dollar, when the hospital bill comes in, they just forward it to you and say, here you are, Mr. Employer, pay up.
But not only that, but then it was the attorneys are brought on board and retained. Then there's going to be permanent disability evaluations. There's going to be ongoing treatment evaluations. It's not just pay the bills as they come in and you're done. There's always some sort of a permanent disability evaluation. And bottom line is, backing up what we were first talking about, I think the day of this is gone, Dennis. I mean, people, as they become that small business and they have to do a W-2 and do the payroll taxes and become that small business, for lack of a better term, again, by the laws of the state of California, if you W-2'd somebody, by law, you have to provide workers' compensation insurance. So basically, you're going to be calling the state fund or whoever and say, I need to buy a workers' comp policy for my employee. Because it's a law, when you have a W-2'd employee, you have to have a workers' compensation policy in place.
Yeah, and you also have to post that information somewhere and let employees know what to do if they hurt themselves on the job.
That's a whole different show. I mean, the postings and the regulations and the requirements. I mean, they just go on and on and on and on.
It is not fun, believe me, and
no.
Which is why everybody likes independent contractors. I'm interested in this the state bill that we talked about, 1344, which is not yet law. If people out there want to do something to have some input as to how, if at all, the law is changed, what should they do?
Well, I would contact Senator Jeff Stone's office in Sacramento and just, first of all, I do a little homework and find out exactly what it is that's being discussed. And right now, primarily, it is the sleep time deduction. And again, finding that middle ground that treats both the employee fairly and keeps the cost down for our seniors. Because as I said earlier, you have employees who want these kind of jobs. They love the live-in. But now these jobs are no longer available, so there you go with that, would you call it something in consequences or whatever?
Doctrine of unintended consequences.
Yeah, that one. Because me as a company, because of litigious California, I've just completely stopped doing live-ins. I don't even do live-ins anymore. So if a client needs 24-hour care and they want to use comfort keepers in home care, they get 3 to 8-hour shifts, and or I'll factor in the overtime, and we'll do 2 12-hour shifts. But until, in my eyes, they clear up the gray area, which has become my mantra now, is stay out of the gray area because we're so litigious. Until the gray area is totally converted to black and white, I just don't offer live-in anymore. It's just too risky as an employer, and so therefore I have no live-in positions for caregivers, which costs jobs. And when a client needs 24-hour care, it's so costly. Now they're staring that bad decision in the face of, I've got to go to a nursing home, or I've got to go to a board and care or one of these other facilities that removes them from their home.
And the board and care proprietors have the same issues when it comes down to it.
Oh yeah, they're still bound by the same wage and hour laws that we've just discussed for the last 20 minutes.
Which makes it very, very difficult. But I think your suggestion that they contact Senator Stone is a great idea. Where's he from? Do you know?
That I don't know. I know he's a Republican senator in Sacramento. I talked to one of his assistants with the last KHTS road trip we did. Very open, love the spirit of compromise approach. Again, everybody's treated fairly. That's the end result of a good deal, right?
Absolutely. In this case, it's even better than normal, because instead of a compromise resulting in both sides feeling slightly screwed, here both sides get what they want. The caregivers get the opportunity for the job, for the work. The patients and the homeowners, if you will, they get what they want, which is the opportunity to allow the patient to stay in the home and have familiar care all day, because some of these relationships last years. I mean, right. I had a client who was a board and care home operator, and in San Francisco years ago, and his client, and I can do this without breaking any confidentiality rules, his client was Joe DiMaggio's sister. And he tells great stories. The 3 DiMaggio brothers, Joe, Dom, and Vince, used to come over about once a month to see their sister and just regale the residents. I mean, they'd hang around for a couple of hours and talk to everybody, and most of these people were old enough to have seen them play. So it was great for everybody. But he wound up in the middle of litigation, which is how we wound up doing business. And he had the city and county of San Francisco's wage and hour department under their local ordinance after him, and we managed to get that thing settled quite favorably to him. Quite frankly, I was very proud of it. But a winning result for everybody.
Right, and again, back to your doctrine of unintended consequences. I mean, it used to be, and I was sort of split on my feelings on this, but it used to be where caregivers in the home care industry, they were completely exempt from overtime under Wage Order 15. Now, as employers, we can all dictate our schedules and control our overtime and what have you, so we would just schedule accordingly. But what you would do, you would have caregivers who loved working, let's say, 5 12-hour shifts, so they would log 60 hours a week, no overtime, nothing was passed on to the client, so the client got to maintain a consistency of the same caregiver. And so then they changed that, and they did give us a little more wiggle room than the regular industries. We have 45 hours a week or 9 hours in a day now that we'd have to adhere to. But bottom line is all we did was pull back on letting these caregivers work 60 hours a week, because now it was no longer legal, and the overtime would have to be passed on to our seniors. So we cut everybody back to stay within the 45-hour-a-week guideline, or 9 hours a day. Well, who suffered in the long run? The caregivers were no longer, they had to go out and pick up a second job because they no longer could work 60 hours a week with me. And then the client suffered because now they had more than one caregiver for that same amount of time coming in as far as their care and that bond that's created and the consistency of the care. So again, your unintended consequences. Caregivers lost hours and clients lost the consistency of their care.
Which was a loss for everybody. I agree.
Right.
Now,
Because,
why don't you go ahead?
Go ahead. No, I was just going to say, because we could go either way. I mean, I don't necessarily agree that a caregiver should work 100 hours a week and not be compensated additional for that. But if that's what they want to do, because I could certainly schedule it the other way. I mean, we could go either way. So whatever benefits the caregiver the best, or whatever benefits the client the best, I'll follow the rules. I get out of the gray area, stay in the black and white. So now we're following all those wage and hour rules. But again, that doctrine comes into play again, where the caregivers had to go out and pick up a second job because we had to reduce their hours, and the clients lost the consistency of the care because now we had to put in another caregiver in the place of those hours that their primary caregiver could no longer work, unless the client wanted to absorb the overtime, which was rare because a lot of our seniors are on a fixed income and a budget.
Absolutely. Now, why don't you tell us, you've got a show on KHTS. Why don't you tell us when it's on and what it's about? Absolutely.
But it's called Aging with Power. And we focus on a lot of the issues that we just have talked about here with our seniors and our adult children who are in that what they call the sandwich generation of caring for aging loved ones as well as raising their own kids. But we visit areas of the entire spectrum. One of my taglines is from the womb to the tomb. But Aging with Power is on the first Tuesday of every month at 11 a.m. I do switch that around depending on my traveling schedule from time to time. I used to do it weekly. It got to be a little burdensome. I'm looking at picking up a couple of more shows a week. I haven't talked to Jerry or Carl about that yet, but to get more consistent, maybe every other week rather than just once a month. But again, I bring subject matter experts on that talk about, anything to do with aging loved ones and seniors. But this last show I had yesterday, we talked about education. So we had, Amy Daniels from the Wish Education Foundation from the Hart High School District, where we talked about, the fundraisers and the great things they do for our school district. And Rob Schwartz, who is a independent college counselor with that whole minefield of kids making that segue from high school to college and the right choice and financial aid. So Aging with Power pretty much handles anything, addresses anything that has to do with this journey that we call aging.
Which all of us hope we're on longer rather than shorter.
Yep. It's something that we're not going to avoid, and that's why I always tell people, you get car insurance because you may be in a car accident. You get homeowners insurance because you may have a fire or a disaster. But nobody looks at long-term care insurance because it's 100% sure we are going to get old. We are going to need care at some point in our life. There is no way around that. So everybody gets the insurance for things that may happen, but ignore the fact that there is a 100% chance that you are going to need care. So look at long-term care insurance. Do some estate planning. Do some financial planning because you are going to need care somewhere in your life. I promise you.
If someone wants to get a hold of you and talk about hiring one of your people, how would they do it?
Well, they can go to, actually I have a microsite. I mean, they can go to comfortkeepers.com, but I also have a microsite, seniorcaresantaclarita.com, or they could just call us right here on Lyons Avenue at 661-287-4200.
Great. Well, feel free to do that out there in the audience. We still are open for questions, 661-298-5487, 661-298-KHTS. Feel free to give us a call or drop a question on Facebook if you want to. And Miles, I want to thank you very much for your time today. And I look forward to having you back on the show because you've got a lot to say, and I think it's of interest to our listeners.
My pleasure, Dennis. Great talking with you.
Thank you. And I think we've got a break coming up, don't we? We do. So we'll be back on the other side of the break on the Legal Line. You are back on the Legal Line. My name is Dennis Kennelly, your host, and we just finished a rather intriguing discussion with Miles McNamara about home care and the wage and hour issues that permeate it and make it hard for two parties that want to get together and do a deal that benefits both. But the law makes it difficult for them to do it. And the fact that the state legislature is trying to deal with that situation with a bill called State Bill 1344 under Senator Stone, and the conclusion was, if you want to give some input into that, call Senator Stone's office in Sacramento. He's a Republican member of the state Senate, and he will be happy to hear your comments. And I think it might make it easier for the legislature to deviate from their normal path of just going straight ahead and benefiting employees, in this case to the detriment of the number of them working, which is a totally unusual situation. I want to talk about our show next Thursday, and we're going to have on with us Ann Learoff, who is once again an experienced labor attorney, and we're going to be talking about sexual harassment, which pops up periodically. Most recently, in the news, all of the people at Fox News and the Fox Corporation who have been accused of sexually harassing female employees, and people are talking about $1-million lawsuits, but let's get down to the level of the practical. The level of the practical is, if you're an employee and feel you're being sexually harassed, what do you do? What is sexual harassment? And if you're an employer, what do you do to prevent yourself from getting stuck with a bunch of liability for things that very often you don't know about it until after they happen? So just as a preview, what is sexual harassment? Well, sexual harassment is one of two types. It's quid pro quo, which means if you want to work here, if you want a job here, you have to grant me some sexual favors. Well, it's either sleep with me or you don't work here. That doesn't happen that much anymore, but it still does, believe it or not, even in this day and age. But the more common one is hostile environment, where employees are entitled by law to a hostility-free environment, a discrimination-free environment, and in differentiating what constitutes that, and what is an employer's responsibility to create that type of work atmosphere, and what does the employee have to do to help the employer keep that promise. Quite frankly, as an employer, if I don't know about it, I can't fix it. So an employee's got a responsibility to let the employer know what's going on. If one of your coworkers is harassing you, keeps asking you out, keeps commenting on your appearance, keeps saying how sexy your appearance is that day, keeps asking you out repeatedly after you've made it clear to them that these kind of things are unwelcome to you, what do you do about it? Well, the first thing you got to do is pick up your employee handbook and read the company's sexual harassment policy. Where do you go? And what happens if it tells you to go to your supervisor, and guess who the person that's annoying you is? It's your supervisor. And that doesn't work. And you've got companies, have got some real clear responsibilities, one of which is that they have to put out and promulgate and make sure employees are familiar with a sexual harassment policy. And the best place to put it is in the employee handbook. I mean, that handbook should not be sitting on your shelf or in the bottom drawer gathering dust. You should read it. It's got a lot of interesting stuff in it. And it's going to tell you what to do, because the only way you're going to make the situation better is to let people, first of all, you have to let the harasser know that what they're doing is unwelcome. That's the first key, because if they don't tell you to stop, unless it's something obvious like you're groping, somebody's groping you or something like that. And then second of all, you got to let management know and read the handbook to find out what management wants you to do. Now, how do you define sexual harassment? You're a kind of aggressive, I'll make you a male like I am, and you're kind of an aggressive male who likes to make comments in order to impress girls, women, to make you more attractive to them. Where do you draw the line? How do you know what's sexually harassing or not? I've come up with a test that seems to work, and that is, if you would be comfortable making the remark or taking the action that you're doing in front of your significant other or your spouse, you're probably okay. And if you're single and don't have a significant other, if you'd be comfortable doing it in front of your mother. And most people, when I do training on prevention of sexual harassment, most people that hear that definition like it. They can identify with it. And that's why the worst day of the year from a sexual harassment standpoint is the dreaded employee Christmas party without spouses and where alcohol is served. We get more complaints arising out of that because guess what? Your governor is not there anymore. The individual that's going to keep you from doing something weird, that basically is going to keep you on your best behavior. And with that analogy, people get it. They really do, because why do you have so much of a problem at employee Christmas parties where alcohol is served? Because there are no spouses and alcohol is being served. So that's why a lot of companies, quite frankly, have stopped that, and much to the chagrin of caterers. So we'll be talking about that, and we'll also be talking about what kind of policies that companies are supposed to have and how they actually work. And also the dreaded R word from the employer standpoint, because just about every sexual harassment claim that you see involves a retaliation claim. Because the employees, one of the reasons that employees are hesitant to go anywhere with these sexual harassment complaints is fear of retaliation. And retaliation can be subtle. It really can. I mean, I've got a case right now where smaller employer and 3 people were complained against by a particular employee. And these people, the remedy that the company came up with was that, okay, we won't assign the employee to work with them anymore. The problem was it took away 50% of the job opportunities for the employee. So the good news is they got rid of the sexual harassment. The bad news is I lost half my work, and I can't afford to work there anymore. So once again, the doctrine of unintended consequences. So we'll be discussing that at far greater length next week, next Thursday at noon with Ann Learoff. I want to thank my producer, Laura Espinoza-London, and our engineer, Aaron Delatorre, and we'll see you next week.